Oh, Stephen, you're muted, so we need you to unmute yourself.
Story of my life lately. Okay, so anyway, it is a pleasure to be here, and I want to talk to you a little bit about Disability Rights Connecticut. The DRCT, as we call it, is a law office located here in Hartford, which focuses on the rights of people with disabilities. We have attorneys on staff, we have advocates on staff, and we have investigators on staff. Our whole focus, as I indicated, is on the rights of people with disabilities. We're an independent, nonprofit organization. We previously were part of the protection and advocacy system of the state of Connecticut. In 2017, we then became an independent organization, and we are part of a nationwide network of disability rights organizations. We take legal cases for individuals with disabilities, and there's no charge for our doing that. Primarily the cases we take are cases which we refer to as systemic cases, cases which will have the most impact on the most number of people in Connecticut. We have federal cases, state cases, and under state law, under US law, there has to be a protection and advocacy office in each state and territory of this country. And DRCT is the firm for the state of Connecticut. Okay, I'm having some trouble moving my slides, but otherwise we're located down on Wethersfield Avenue in Hartford, and we do in fact keep track and follow the other agencies throughout the country with respect to what types of matters they are looking into on behalf of persons with disabilities. DRCT exists because people with disabilities did not always have equal rights. And you all know that very well. That many people with disabilities did not have access to jobs, education, voting, medical care, and there's lots of barriers that still exist, including what we're talking today, and that's housing. Ability to find housing, get secure and safe housing. We report to the federal government to ensure that the state of Connecticut is providing equal services to people with disabilities. What we're doing is attempting to make sure that all persons in the state of Connecticut, be they disabled or not disabled persons, have equal rights to equal services. And you can certainly contact us if that is the case. If you feel that you haven't gotten that, you can certainly contact our office and we'll be happy to talk to you about that. Okay. DRCT's mission, I'm sorry. Can I go back a second? I'm sorry, I might tell you. I have a problem. I'm having issues. All right. DRCT's mission is to advocate, to educate, investigate, as well as pursue legal, administrative, and other remedies to advance and protect the civil rights of individuals with disabilities to participate fully, equally and fully in all facets of community life in Connecticut. We want everyone to be on an equal footing when it comes to all areas of life in Connecticut. And that is what we are attempting to do, and that is what we are fighting to do on behalf of those with disabilities. We mainly are referring to and are relying upon the Americans with Disabilities Act, which is a federal act and which protects people with disabilities from being treated unfairly or differently in the provision of housing and conditions of housing. One of the things that we've become involved in recently has been the United States Access Board and working with them on specifically building of new properties. We work with architects. We are working with people who are designing new buildings, who are designing apartment buildings, to make sure that all those facilities are accessible to persons who are disabled. There's no reason that a disabled person should not be able to move into any given apartment building or house or other building because there are restrictions. There should be no restrictions. We've been working with the designers and people building those properties to make sure that they are accessible to everyone. And so that's another area that we've, in addition to the making sure that people have reasonable accommodations and making sure that people have reasonable modifications so that they can remain in their property. We're also wanting to make sure that when those properties are built at the outset, that they are built such that they are ready and able for anyone to move into at that point. And one of the final slides that I've got is adults with disabilities. And this is something which I think indicates what the real problem is that we see very often, is that, again, the approximate number of adults with disabilities by ethnicity and race. At the top, it says Black population is identified with the highest rate of disability at 25%. So the issue of disability has a far greater impact on minority populations, on also shows American Indian populations, other Hispanic populations. So there is it is very, very, very impactful on people who are non-white, and as a result, and who are disabled. And so we need to make sure that what we're doing when we're looking at property, when we're looking at housing, when we're looking at providing housing for individuals, that what we are doing is taking into account the disabilities that individuals have and other factors that we need to consider to make sure that we have equality across the board with respect to housing. And And this is just one last slide that we put up that thought was pretty impactful, and that's it. When you erect buildings that are not accessible to the handicap, you enforce segregation. And that's one thing we don't want. We don't want to enforce segregation by any means. So I'm probably going to turn it over right now to Rashida. And thank you very much. It's a pleasure being here.
Thank you so much, Stephen. So I am going to start with a brief introduction on the Connecticut Fair Housing Center and what we do. And then I am going to pass it over to my colleague, Jessica, that will give a more in-depth presentation with regards to the Fair Housing Act and how it covers individuals that have disabilities. So the mission of the Connecticut Fair Housing Center is simple. We are a statewide private civil rights nonprofit with the goal in mind to ensure that all people have equal access to housing opportunities in the state of Connecticut. And we do recognize that housing discrimination disproportionately affects people with low incomes. So we focus on the intersectionality of poverty and housing discrimination. You can divide the work that the center does into these categories. So we do foreclosure prevention and intervention services. We do education and outreach and testing, which is an investigative side of what the center does. We do policy advocacy because we are aware that there are years of discriminatory policy that have been put in place that have disenfranchised people today. We also do eviction defense by empowering the Connecticut tenants to be able to know the eviction process and be able to come together and unify. And last but not least, we also provide fair housing enforcement to housing providers or anyone in the housing arena that differs from following the Fair Housing Act. So when we talk about the Fair Housing Act, it was passed in 1968 in the wake of Dr. Martin Luther King Jr.'s assassination. And this act was brought across President Johnson's table to bring unity to the country after riots had erupted all across the country following the assassination of Dr. King. So when we say that Congress passed the Fair Housing Act, it was a lot more that goes into the passage of that act, where it still remains the most contested and filibustered piece of legislation that we have to date, right? But the Fair Housing Act comes to prohibit discrimination based on your membership in a protected class in all forms of housing transactions. And Connecticut has taken the step to add additional protected classes, making Connecticut's fair housing protections some of the best in the country. So when we talk about protected classes, on a federal level, it is illegal to discriminate against anyone in any housing transaction based on their race, color, national origin, sex, disability, religion, or familial status, the presence of children within a family. The state of Connecticut has added ancestry, marital status, age, sexual orientation, lawful source of income, gender identity and expression, and veteran status to their statewide protected classes. So for a moment, I want to talk about discrimination and how we define discrimination under the Fair Housing Act. So we define discrimination in two ways. Differential treatment is flat out treating people differently because of their membership in a protected class. So for example, if a housing provider would say to someone, I am not going to rent to you because you have a wheelchair, that would be differential treatment because they're treating them differently because they have their membership in a protected class. Disparate impact is a little bit more dicey to explain. It is a neutral rule that has a greater negative effect on members of a protected class. So a good example that we use here is having a blanket no arrest or no conviction policy when you are a housing provider. Now, if you looked at the list of protected classes, you recognize that people with a criminal background are not on this list. But we know that criminal background disproportionately affects people of the race and color federal protected classes. So a neutral rule like that put in place will have a greater negative effect on members of a protected class. So that is how we define discrimination under the Fair Housing Act. So what does this discrimination look like in housing, right? The misrepresentation of the availability of housing will look like, let's say you call a housing provider and you guys seem to be having a very good conversation, and all of a sudden the conversation sways to whether you have children or not. And you say that you do have children, and all of a sudden the unit becomes unavailable. You may want to get someone to investigate that, so you call the center, and we call that same housing provider, have the same conversation, but when the question of children is brought up, we say no. And all of a sudden the unit is available again. So misrepresenting the availability of housing is a violation of the Fair Housing Act. Flat out refusal to rent or sell to someone due to their membership in a protected class. We do see discriminating in terms and conditions when it comes to our population that has disabilities, where a housing provider or a landlord will request that a person that may have a wheelchair pay an extra security deposit or get renter's insurance just because of the fact that they have a wheelchair. A good rule of thumb is what a housing provider does for one person, they have to do for everyone. And if they're only asking for an extra security deposit or asking anything of an individual just because of their membership in a protected class, then that is discrimination. Discriminatory advertisement, we see that people will put out ads with regards to their units that are for rent, and they'll use phrasing such as able-bodied prefer or better for single professional. Those are discriminatory advertisements and also a violation of the Fair Housing Act. Use of threats, intimidation, or coercion in any housing transaction is a violation of the Fair Housing Act. And lastly, discrimination with a smile looks as if it is laden in goodwill, as if the housing provider is trying to help the individual, but unfortunately, it's steering. So a good example of that is you may have a person that has a disability look at a unit, and the housing provider will say something to the effect of, well, there aren't many medical facilities in this area, and I don't think you'll be comfortable in this unit because of that. But if you go to the next town over, you're able to access medical care, and I think you would be more comfortable renting in that town. So that is steering, right? It's not up to the housing provider or a landlord to determine the comfort of their tenants or potential tenants. So if you feel that any of this has happened to you, or you see any of this, not just for you, but maybe a friend or a family member that is trying to find housing, please give us a call at the center so that we're able to assist you, because our mission is to make sure that everyone has equal access to housing opportunities in the state of Connecticut. So lastly, one of the things that I want to touch on are the effects of this housing discrimination. What does it look like in the state of Connecticut? So we know that the United States and Connecticut still remain highly segregated, with 67% of the population of color living in 8% of Connecticut's towns. We see people with disabilities and people who have housing vouchers, they experience discrimination at higher rates than every other protected class. And what does this look like in real time? Here is a segregation map of the state of Connecticut, where you can see that 67% only populated in 8% of towns represented here in that map. So it's very important that if you or someone that you know is experiencing housing discrimination, that you report it as soon as you get that chance, or as soon as you get that urge, to the Connecticut Fair Housing Center, so that we're able to assist this map in looking more dark green in these areas where you see the light green color, right? We're trying to make sure that everyone has access or equal access to housing in the state of Connecticut. And with that, I'm going to pass it over to Jessica, and she's going to give you a lot more detail on the protections of the Fair Housing Act. And we're going to get into the letter generator after. So Jessica.
Great. Thank you, Rashida, and welcome everyone. I'm happy to be here today to talk about reasonable accommodations and disability rights. I just wanted to say, as I get started, I'm going to go through the laws here and how they specifically apply to disabilities and reasonable accommodations. But Stephen, I wanted to invite you to jump in wherever you feel is appropriate, if you want to add anything, if I'm missing anything, or if you can think of any stories or situations that you've dealt with that relate to any of these points. So feel free to pop in whenever. So when we're evaluating whether discrimination is at play, we ask three questions. The first one is the complainant protected? So is there a law that applies here that applies to the tenant's protected class? So in terms of disability rights, there's three main laws that we use. Section 504 of the Rehabilitation Act of 1973, the Federal Fair Housing Act, and the Connecticut Fair Housing Law. So let me change my slide. Section 504 of the Rehabilitation Act was the first civil rights law for people with disabilities. So this prohibits discrimination on the basis of disability for programs, activities, and services that receive federal financial assistance. So this includes housing authorities and government-run or government-subsidized housing programs, but it does not apply to housing providers who rent to tenants holding Section 8 vouchers or RAP vouchers. So if you have a tenant with a voucher, then Section 504 won't apply, but if a tenant lives in a property that receives an in-place Section 8 subsidy or some other type of HUD or federal funding, then Section 504 would apply. The analysis of the law under Section 504 when it comes to reasonable accommodations is not terribly different than the Fair Housing Act. So we usually operate under the Fair Housing Act. So that's the federal law that Rashida mentioned, and it provides protection for all of these protected groups, including disability, which was added to the law in 1988. The Connecticut Fair Housing laws also include protections for people with disabilities, along with the other protected classes that Rashida mentioned. So disability has a legal framework under the Fair Housing laws. Several different definitions. The first one is a physical or mental impairment that substantially limits one or more major life activities. And so all of these have legal definitions, and I have them here. But a physical or mental impairment is a condition or disease that affects the mind or body. It must substantially limit, so that means for a long period of time or a great degree, and then one or more major life activities. So that could be walking, talking, breathing, seeing, hearing, caring for yourself, but it can include pretty much any other type of major life activity. So if somebody has anxiety disorder or depression, that is considered a major life activity because that can impact your ability to sleep, your ability to interact with others and socialize or care for yourself. So disability is a pretty broad umbrella under the Fair Housing Act. The second and third definitions the second is a record of having a substantial impairment or receipt of SSDI or a history of treatment or hospitalization or something like that. It's important to note that if someone receives Social Security disability, then they will presumptively be considered disabled under the Fair Housing laws. But if someone applied for disability and did not receive disability, that doesn't mean that they are not considered disabled under the Fair Housing laws. So that's an important thing to keep in mind. The third definition is considered by others to be disabled. So this may come up in the case of elderly people who may not have a disability, but who may be perceived by others, such as a landlord or a property manager, to be disabled. And so they can take advantage of these disability rights protections if they're considered by others to be disabled. The next question that we look at is whether the property is covered. Most properties that are considered dwellings are covered by the Fair Housing laws, but there are a couple exceptions to both of the state and the federal law. The Federal Fair Housing Act exempts owner-occupied for family if the owner actually maintains one unit as his or her living quarters. So if an owner lives in a unit that has three other families living there, then the Federal Fair Housing Act would not apply, and the landlord would not be required to make reasonable accommodation or to not discriminate. The discrimination isn't considered legally actionable discrimination in that type of case. That also applies if it's a single family house owned, sold or rented by an owner. There's multiple exceptions though. So if the owner owns more than 3 single family houses, or they use a real estate agent or a broker, or they put the discrimination in writing, verbally says, oh no, I'm not going to rent to you because I noticed that you have a disability, or they post an advertisement kind of advertising that they're not going to rent to you, not rent to someone because of their disability, then the Fair Housing Act protections would not apply. Connecticut is a little different. Connecticut exempts owner-occupied 2-family houses or owner-occupied rooming houses. So the important thing to remember is that in Connecticut, housing providers have to follow state and federal law. So if a property is exempted by federal law because it's an owner-occupied 4-family, the state law exempts owner-occupied 2-family. So just because the federal law might not apply, the state law will have to apply. So landlords need to follow the state and the federal law, and the state law tends to be a little more restrictive there when it comes to the exemption. Okay, so this is kind of the bulk of our presentation, but the question is the behavior legal? So we're looking at disparate treatment and disparate impact, like Rashida mentioned. So disparate treatment, Rashida kind of went all through these, but there's a couple other things here that I'll mention. You can't refuse to rent or sell to a person because they're disabled or because a member of the household is disabled. That also includes what we kind of consider, benevolent discrimination, where, as Rashida mentioned, if a landlord purports to be concerned that medical providers aren't nearby, or if they, want to insist that someone can't rent a second floor unit because they use a mobility device, that's discrimination, because that's not a determination that a landlord can make for a tenant. The tenant and the person with a disability is in the best position to determine what type of apartment they want and what works for them, and the landlord should not be substituting their own judgment. Landlords also cannot inquire into the nature or severity of a disability. So there's absolutely no reason they would need to know any details about your disability status or your treatment or how long it's expected to last, anything like that. Housing providers cannot have a preference based on type of disability. So, I had a case once where someone was seeking to rent a unit and the landlord learned that they were coming out of a nursing facility. They assumed that the person had a mental impairment of some sort and refused to rent to them. And then at the hearing, they said, well, if we knew that the person had a physical disability, that would have changed everything, but not in terms of the law. Like, landlords can't prefer physical disabilities or over mental disabilities. It doesn't make a difference. They shouldn't have any type of preference at all. Landlords also shouldn't have different rules for people who are disabled versus everyone else. So they can't charge a higher security deposit because they're afraid that someone's wheelchair might cause damage to the walls, or they can't restrict access to a pool or a gym based on safety concerns that they think may be presented. It's up for the person themselves to decide what they're comfortable with and what amenities they may want to use. And then also they can't steer people who are disabled, so can't require people with disabilities to be on the first floor if that's not what they want. Here's some other examples that we've seen. So requiring a tenant to get insurance because they use a wheelchair, that's not something that the Fair Housing Act would allow. Requiring tenants with disabilities to get a co-signer or a guarantor, but not requiring this of anyone else would be illegal. The same would go for if someone received some type of voucher or SSDI. If they wanted that tenant to get a guarantor or co-signer, that would not be allowed. That would be an unlawful term and condition that they're imposing on someone due to their disability status. And third, we have here Landlords cannot require a letter from a medical provider stating that the person can live independently, and they cannot advertise independent living because that's discrimination on the basis of disability, and sort of seeks to make distinctions between people based on the severity of their disability. So reasonable accommodations are a pretty major area of practice for our office. A reasonable accommodation is a change to a rule, policy, or practice that may be necessary to afford a person with a disability an equal opportunity to use or enjoy a dwelling. So that's the legal definition. It's important to remember that a housing provider must grant a reasonable accommodation unless it poses an undue financial or administrative burden, or it would change the fundamental nature of the program. So it's important to remember that some cost to the housing provider is allowed. So a housing provider can't say, well, this is going to cost me $50 to give you this accommodation. So I'm not going to give it to you. No, it has to be an undue financial burden. And that's something that's determined really on a case by case basis. If you're asking that, for example, we've seen cases where a building has an elevator, but it's not functional, or it's like sporadically functional, and somebody is asking that the elevator be fixed as a reasonable accommodation. We would have to look at the cost. That if it costs $20,000, that may or may not be reasonable. It just depends on sort of the finances of the housing provider and sort of the details surrounding that. So just because it's a big cost doesn't mean it's an undue burden, but it just depends on the situation. An administrative burden is something that would cause sort of an undue amount of paperwork or staff time or something like that. We don't see that too often. I think typically the excuses that we see for landlords not to grant reasonable accommodations is that's an undue burden financially. The other reason that a housing provider could give to deny a reasonable accommodation is if it would change the fundamental nature of the program. And so that would be, if a tenant needed assistance with grocery shopping or something like that, and they ask the landlord to provide that service. If the landlord doesn't provide that type of service to other people, then it would change the fundamental nature of the program to ask them to have a staff member go and provide groceries for someone. All right. So how to request a reasonable accommodation? It can be verbal and it doesn't have to be in writing. So that's, it's important to know that if you verbally ask for a reasonable accommodation, that is a legally sufficient way to request a reasonable accommodation. However, we usually not require, but suggest to people that they do put the reasonable accommodation in writing with the date. And so that way you can track, okay, I made the request on X date, I've been waiting this long, and the housing provider then can't turn around and say, oh, I didn't know, I never received it. It's good to have a paper trail, particularly with a date. So we always suggest that people do make the reasonable accommodation request in writing with the date and keep a copy for themselves. Oftentimes housing providers, such as housing authorities or bigger housing providers, will have a form that they want tenants to use. So sometimes, I'll make a reasonable accommodation request for someone, and then the housing provider will say, well, no, you need to do it on this form. And so there's no reason that someone would have to use the housing provider's form. You can make the request however you want, and the HUD, there's good HUD guidance on requesting a reasonable accommodation, and it specifically says it doesn't have to be made on the housing provider's form. The request also doesn't need to use the term reasonable accommodation. So there's no magic language that a tenant has to use in order to be entitled to a reasonable accommodation. But if you come to our office and we get involved, we usually do use that term to signal to the housing provider that this is a request that they're required to make under the fair housing laws. Here are a couple examples of reasonable accommodations that we see most commonly. So a reasonable accommodation can be an assigned parking space. That's one that we see all the time. It could be a transfer to a unit that meets the tenant's disability-related needs. It could be permission to have a live-in aid. It could be a request for an increased voucher size. So we see cases sometimes with children where the children are sharing a bedroom, but they need separate bedrooms and space due to their disability. And so we've helped people request from the housing authority an increased voucher size to accommodate the kids' needs for their own bedrooms. It could be a request to communicate in writing rather than in person or by phone. That's something that should be easy for the housing provider to grant. Could also be a request to overlook poor credit, landlord references, eviction, or criminal history if the circumstances behind the credit issues or the person's experience with eviction or with their former landlord or their criminal history was related to a disability. So, in that case, you can make a reasonable accommodation, but it's very case by case specific about kind of the nuances of whether the landlord will have to grant it. And it's always helpful to have some medical documentation in a case like that. In most cases, it's good to have medical documentation, but I think especially in a situation like that, we would recommend it, having a doctor or a medical provider being able to explain why the person needs the accommodation. Other reasonable accommodations include accommodations to zoning. And so that could come up where someone is requesting that a town or a city make a change in their zoning ordinances to allow a group home or allow exceptions to parking regulations. So if the town has some kind of rule about, parking can only be on the side of the property and there's a large hill, something like that, and the person needs to park closer on a flat surface, then they could request a change in the zoning ordinance to accommodate their need for parking on a flat surface near the door. Or if the town has some kind of zoning ordinance about group homes, including the number of people who are allowed to live together who are not related, or whether apartment style buildings are allowed within a certain zone of town, that could be a reasonable accommodation that someone could make to the town. The town should have a procedure for residents to make reasonable accommodations, but of course that doesn't always happen. So, if you're encountering a situation where you need assistance in dealing with the town to make a reasonable accommodation, can be a little bit tricky. So I would suggest, feel free to reach out to our office if that's something that you need help with. And then another very common reasonable accommodation request that we get at our office is emotional support animals. So I'm going to go through the law on assistance animals as reasonable accommodations because it's something that we see all the time. And I think it's something that's a bit of a hot topic among landlords and tenants. And I think it's a good illustration of how the reasonable accommodations laws work. So assistance animals must be permitted if having one is necessary to afford a person with a disability an equal opportunity to use and enjoy a dwelling, including in public or common use areas. So under the Fair Housing Act, assistance animals are defined as trained service dogs or trained or untrained animals that provide emotional support or other assistance. Now, this is an important distinction. There's a lot of confusion among tenants and landlords and other people alike about emotional support animals versus service animals. The ADA only recognizes trained service dogs and not emotional support animals. But the Fair Housing Act is much more broad. And so it allows, you can have a service dog, a trained service dog who performs a task, or you can have an untrained animal that provides emotional support or other types of assistance, and it doesn't have to have training. People can also have other types of animals under the fair housing law. So there's cases where people have miniature ponies, and you could have an emotional support cat and other animals that might provide emotional support or other assistance. So I'm going to go through some frequently asked questions. So I already discussed this. Americans with Disabilities Act are only allow dogs with trainings, but the Fair Housing Act, which applies to almost all housing providers, includes dogs, cats, birds, miniature horses, other animals. Assistance animals can perform tasks. So they can be guide dogs for people with visual impairments. They can alert individuals to sounds, noises. They can provide protection or rescue assistance. They could pull wheelchairs. They could sense seizures or other medical events and retrieve objects. Or they can provide emotional support such as comfort, responsibility, companionship. When I'm doing this training for housing providers, I think there often is skepticism about emotional support animals, and people claim not to understand why someone would need an emotional support animal. But I always explain sometimes people have a difficult time getting out of bed or leaving their home, and having a dog in particular may help them establish a routine, provide exercise. Having to give the animal food and water and take care of them hygienically can be really helpful to people who might otherwise struggle. So housing providers usually have a lot of questions about emotional support animals in particular. But the only questions that there really should be asking themselves in evaluating the request is, does the person requesting the accommodation have a disability? So do they have a physical or mental impairment that substantially limits one or more major life activities? And does the person making a request have a disability related need for the assistance animal? So does the animal provide some type of assistance, perform tasks, or provide emotional support? If the answers to 1 and 2 are yes, then the provider must make the accommodation. Of course, it's not that easy because often housing providers feel they're entitled to some type of documentation. So this is what HUD says. If the disability is obvious and the need for the change in the rule, policy, or practice is obvious, then the housing provider cannot ask for written documentation or medical documentation. So if a person who the housing provider knows to be visually impaired needs a guide dog, then they shouldn't be asking for medical documentation because the disability is obvious or known to them, and the need is also obvious. If the same would go for if somebody wanted to install a ramp because they use a wheelchair or they use another assistive device, the housing provider shouldn't ask for medical documentation regarding their disability because it's obvious. The housing provider can see that the person uses an assistive device, and the need is obvious. If there's stairs and the person has a wheelchair and they're asking for a ramp, then that's obvious. There's no more information that should be needed by the provider. If the disability or the need for an accommodation is not obvious, then the housing provider can request reliable documentation. So what that could be is a letter from a doctor, psychologist, psychiatrist, or social worker. A housing provider should not be demanding a diagnosis, access to medical records, or access to a provider. Um, we see varying demands for different types of information that housing providers make. It could be a way to discourage someone from pursuing their reasonable accommodation request. And I know tenants often feel sort of intimidated if the landlord's asking for more than the tenant is comfortable providing. And so if something like that happens where a housing provider is demanding to speak to a doctor or review medical records, we always suggest you seek out legal advice before giving up that privacy. The documentation should be sufficient if it establishes that the person has a disability and that the animal will provide some type of disability-related assistance or emotional support. The question of online certifications is a real hot topic right now, related to reasonable accommodations. So an animal does not have to be certified or registered. There's no national or statewide animal certification or registry. It's just not something that exists. There's websites that kind of make it seem like they are related to the government, and they offer certifications or other documentation for someone to bring on an airplane or show to a housing provider, but that's not something that's required, and those websites may trick people with disabilities or cause confusion by making people think that that's something that is required. And so we see this kind of on both ends, where a tenant will say, my dog is registered or my dog is certified, and think that that's enough, when in fact they may need to provide medical documentation from their doctor rather than this certification form. But then landlords will often ask tenants, well, is your dog certified? Is your dog registered? When that's not something that is required under the Fair Housing Act. online or app-based therapists or social workers are very common, especially now during the past year, during the pandemic. You know, we've seen a lot of these online providers pop up. And, you know, just because it's an online or app-based therapist or social worker doesn't mean that they're not a legitimate provider. So I think, you know, some of the websites that offer these certifications or registration documents may connect someone with a social worker who will sort of write a letter without having really evaluated the person. So that's probably not reliable medical documentation. But if you are communicating with a therapist or a social worker online through an app, through a video chat, that may be sufficient reliable medical documentation. It just depends really on the specifics of that situation. So when can a provider say no? They must make the accommodation unless doing so would be an undue financial or administrative burden or a fundamental alteration of the nature of their services. Now, an emotional support animal or a service animal really is not going to be an undue burden or a financial alteration. Um, if the provider is unsure about whether an individual with a disability has a disability or disability related need for the accommodation, the provider should engage in the interactive process with the individual. They cannot indefinitely delay granting the accommodation or simply ignore the request. We see this happen frequently, unfortunately, where the housing provider just will not respond to the individual making the request, and the individual is in limbo. You know, can I get this animal? If I get this animal, am I going to face an eviction for violation of a no pet policy? So if somebody is having trouble reaching their landlord, or the landlord just kind of keeps pushing them off, then we suggest that you seek legal assistance to try to get that answer. One other thing that's important to mention about the undue financial or administrative burden is that landlords might claim that their insurance won't allow pets or won't allow animals, particularly dogs, or might have size restrictions or breed restrictions, and the landlord will say, well, you know, it's gonna the insurance is gonna drop me from my insurance if I allow you to get a pit bull or a Rottweiler or one of those types of breeds. That's something that we would evaluate on a case-by-case basis, but HUD has said that their housing providers cannot have size, weight, or breed restrictions. So that's kind of the blanket rule. A housing provider can't say, yeah, you can have your emotional support animal if it's under 25 pounds or if it's not one of these breeds. If a provider wants to say, no, I'm not going to let you have this dog because my insurance will drop me, then they should be prepared to prove that. And if it really is just a matter of the insurance might go up in cost somewhat, then that might not be considered an undue financial burden, but it really depends on the specifics of the situation. So I mentioned a couple of these already, but sometimes housing providers want to put restrictions or conditions on someone who's seeking an emotional support animal. So they cannot charge someone a pet fee or a pet deposit. They can charge that for people with pets, but an assistance animal, either emotional support or a service animal, is not a pet. So tenants shouldn't have to pay fees or deposits. They cannot require people to get insurance for a reasonable accommodation. Breed restrictions and size and weight restrictions are not permitted. Requiring that the animal have the state mandated vaccines, that's probably an acceptable condition. Licensing, if the town requires a license, then that may be an acceptable condition, sort of depending on the situation. And then rules regarding behavior may be allowable as well, but it really depends what it is. If they're overly restrictive and kind of being used to not allow people to have their emotional support animals, then that may be a pretextual reason to say no, but it really depends on a sort of the case-by-case basis. But in general, people should clean up after their dogs and keep their dogs under control, not lunging and barking at people to the extent possible. If an assistance animal causes problems, that's something that may happen because assistance animals are still animals. So the rule is, according to HUD, that if a specific animal is a direct threat to people or property, then the housing provider can take steps to have the tenant or the animal removed. However, the housing provider needs to do an individualized assessment of the specific animal, and it can't be based on speculation or fear about animals, this animal in general or other animals. So if, we'll see this a lot if someone has a pit bull, neighbors might be scared of pit bulls, the property manager might be scared of a pit bull, but if this particular pit bull hasn't done anything, then the housing provider can't claim that they're a direct threat and ask them to leave. If the dog has caused or animal has caused injury to another resident or another animal, then the housing provider and the tenant should work together ideally to determine if there's another accommodation that could reduce the risk of harm. So if a dog, lunges at a neighbor and then neighbor is scared, that is not cause for eviction or a demand to get rid of the animal, but instead the tenant and landlord could consider, is it appropriate for the dog to have a muzzle? What about a shorter leash? What about limited hours for bringing the dog outside or additional training? I've also seen cases where the dog has gone on medication, whether it's like an anxiety medication or more of a natural like calming medication, but there's all kinds of options that should be employed before just evicting someone or telling somebody, you have to get rid of your dog. If the animal causes damage to the unit or to the greater property in general, if the housing provider has a practice to require tenants to cover costs of repair to the unit or common areas, then they can require the same for individuals with assistance animals and for damage caused by assistance animals. But if that's something, if the landlord is seeking to hold a tenant responsible for damage to a common area, but they don't require other tenants to pay for damage they personally may have caused to a common area, then that would be unlawful. So now quickly, we'll just jump into reasonable modifications. A modification is a physical change that a person with a disability may need in order to use and enjoy their dwelling. So as I mentioned, it could be installing a ramp, could be widening doorways, could be installing grab bars, any physical changes to the inside of the unit or the outside of the unit. Typically, that will be done at the tenant's expense unless the landlord receives federal operating subsidies. So that does not include a Section 8 voucher, but if there's an in-place Section 8 or in-place other type of subsidy, then the landlord is responsible for making the modifications. Does not apply to low-income housing tax credit or Section 8 voucher properties. A landlord must agree to make the reasonable modification. In a case where it's a federally funded housing provider, again, need to look at the cost to the owner versus the usability to the tenant. It can be required, in the case of an elevator, as I mentioned, or some other sort of more expensive modification, the cost might be deemed reasonable, even if the owner has to postpone other improvements to the property. But this is really a case-by-case evaluation. So if someone is dealing with this, feel free to call our office and we can look into it more. Modifications should comply with local codes, and a landlord can require that. If a person is asking for a modification, the landlord can say, yes, I'll allow you to do it, but it has to be done according to the local code. The landlord cannot require an alternative design that they think looks better. So that's something that may come up. I've had that come up in the case of a ramp where someone wanted a very simple sort of metal ramp, and instead the landlord wanted a large like wooden structure that was painted to match the siding, and that was not a permissible alternative design that the landlord wanted them to do. For maintenance for modifications, if the housing provider would maintain the area of the property that, so for instance, if it's a ramp and the landlord clears sidewalks and walkways and outside spaces from leaves and snow, then they should maintain the ramp. But if they don't, then the tenant will have to maintain it themselves. Landlords, when a tenant is moving out, a landlord can require the tenant to restore interior modifications to their original condition if reasonable. Now, what is reasonable? It really depends, again, on a case-by-case basis. But exterior modifications do not need to be restored to the original condition. So finally, my office, the Connecticut Fair Housing Center, we have a disability letter generator on our website. So I wanted to quickly walk everyone through that in case you haven't seen it. But before I do that, Stephen, was there anything that you wanted to add? I know I've been talking a lot, but I'm happy to take a break if you want to add anything.
No, not really, but I just wanted to thank you for talking about the animals and the pets. We get a lot of calls for those as well. So that was very helpful information.
Okay. All right. So bear with me as I try to work on the technology here. Okay. So hopefully everybody can see our website that I have up here. Stephen, can I ask you, do you see the Connecticut Fair Housing Center website?
Looks good from here.
Okay, thank you. So if you go to our website, ctfairhousing.org, click on disability letter at the top of the website. So this is the center's interactive self-help guide for requesting a reasonable accommodation or modification. So this
Sorry,
is
Jessica, do you mind zooming in just a little bit?
Yes, if I can figure that out. I'm trying. Marissa, do you have
Or a
any?
control plus, maybe?
All right, let's give that a go. Oh, there we go. How's that?
Oh yeah, beautiful, thanks.
Okay, great. Okay, so I'll walk you through how to do this. If someone, if you need to make a reasonable accommodation and you're not tech savvy, you can always call our office and we can help you. But this is something that is designed for people to be able to use by themselves or with an advocate. So you just need to agree to our terms and conditions, submit. Okay, so step one. If you're making the request for yourself, if you're a person with a disability who needs to make a request for accommodation or modification, you just click that. If you're making the request on behalf of someone else, you can click the second button. So that's what I'll click here. So you provide your own contact information. So I'll just do myself. So I'm just typing in my name, my job title, staff attorney, my company, which is Connecticut Fair Housing Center. Type in our address, which is 60 Papalusco Court in Hartford. My phone number. And my email address. Then you just hit next. So then this will, when you're on step 2, it brings you to the client or the tenant's contact information. So I'm just going to make up, we'll just use John Doe so I can show you how to do it. So you just type in their first and last name, type in their address. I'll just use the sample one here. I'm going to try to skip using the client or the tenant's phone and email, and we'll see what happens. I'm also going to do, they ask for the landlord's contact information to sort of populate the letter. So I'll do Jane Doe as the landlord. Company, 456 Main Street. Okay. I'll just do a fake phone number. Okay. A fake email address. Okay, so the final question after asking for the client or tenant's contact information and the landlord's contact information, it asks whether your client's landlord lives in the same building or does not live in the same building. And that can, that makes a difference because of the exemptions. So if it's a, if it's an owner occupied two family, then the landlord may not have to make a reasonable accommodation or modification. In this case, I'll say my client's landlord does not live in the same building. Well, all right, it wants a phone number for my client, so I'll just use this fake one. Okay, so step 3. It's asking you to determine whether you're making a reasonable accommodation request or a reasonable modification request. So again, an accommodation is asking for an exception to a rule, a policy, or practice. A modification is a structural change. So in this case, I'll do a modification. Then it brings up some information that we were discussing before about the funding or the paying for a modification, and says, owners of private housing are not required to pay for modifications. Your client still may request a modification, but your client may have to pay for the modification themselves. Sometimes you yourself, if you're a tenant, or if you're working with someone who's a client of yours, they may not know if they are in a subsidized housing. I've seen that, where people might think HUD is involved somehow, but they don't know. They don't know how, they don't know what the program is. So, it might be good to do some research and not take your client's word for it if they're not sure if there's funding or what type of funding is involved. And if it's a particularly confusing or complex situation, definitely feel free to reach out to our office or to HUD. I mean, HUD or the state should be able to tell you the funding source. Okay. Step 4, my client is limited in my client's ability to do the following activities. So all of these are examples of major life activities. So in this case, because I'm requesting a modification, I think I will do walk. And so over here, it says my disability limits my ability to walk. I'm also going to add climb stairs, because I'm going to ask for a ramp. So let's see what happens. Okay, step 5. Because of my client's limitation, my client needs the following modifications to my client's unit. So you can select any of these options, such as install a chairlift, install new carpets, install railing, install a ramp. That's what I'll select. Or if it's something different, you can just type that in the other box to the right of the check marks. So I'm going to be requesting install ramp. So it says, I need the following reasonable accommodation, modification, install ramp. Okay. So step 6. In general, your client should give their housing provider up to 2 weeks to respond to the request. If the request is urgent, specify an earlier deadline. So in this case, 2 weeks is May 13th. So I'll just leave that there. But if it is something that, you need to know by the end of next week or this week, you can change that date. Okay. So that's it. That's all you need to do. It's, 6 steps to creating the letter. I will show you what the letter looks like. Okay. Oh. Here, I'm going to have to change. Okay, hopefully everyone can see this. Marissa, are you able to see my screen?
I am, but same thing. If you wouldn't mind zooming in just a little bit.
Okay, but you can see the letter?
Yes.
Okay, great. Okay, so here's the letter based on the information that I provided. So it has today's date, April 29th. It has the fake landlord information that I put in here. for the subject line, it says the name of the tenant or the client. So John Doe requests for reasonable modification. And then the letter is very simple. You know, dear Mr. Doe, my name is Jessica Labrensis. I'm writing on behalf of John Doe, who resides at, you know, this address. My client is an individual with a disability that limits my client's ability to walk, climb stairs. Accordingly, my client is requesting the modification described below. This modification is necessary to afford my client full and equal use and enjoyment of my client's home. My client requests the following structural change in their apartment or other part of the housing complex: install ramp. Please respond in writing by May 13th to inform me whether you will grant my client's request for a reasonable modification. I can be reached by phone at this fake phone number I gave, or by email, and then gives the email address, you know, sincerely, my name. So this is a letter that, you know, it can be sort of awkwardly worded. I will say that, kind of depending on the specifics of what you're asking for. You're able to, at the top, you know, it says enable editing. You are able to edit it. So if you want to fix it a little bit or add, you know, add some different wording, you can do that. But this is a good kind of very basic start to the letter. I'm just going to pause this. Well, okay, I wanted to show you one more thing. Let's see. No. I'm going to go back. Okay, so I'm back to our website. You can also download a doctor's note request form. So that can be helpful if the doctor feels a little bit like uncomfortable or too busy to write a note. So I'll show you what this form looks like. This is kind of similar to forms that a housing provider might provide. Let's see. Okay. All right, so hopefully everybody can see this. I'll try to zoom in. But this is just kind of a very basic doctor note request form that people can print out, just with the name of patient to the doctor. I'm asking my housing provider for a reasonable accommodation or modification. I need you to fill out this form so I can give it to my housing provider. And then it says, number one, does the patient named above have a substantial impairment of a major life function? Yes or no? Number two, describe the things the patient cannot do as a result of his or her substantial impairment. And number three, specify what change in the rule, policy, or practice is needed. The reason that it requests that the doctor explain what the patient can or cannot do as a result of their disability is to show the connection between the disability and what the provider and the tenant are asking the housing provider to allow the tenant to do. And then they just need to sign and date it. And that's something that the doctor could submit directly to the housing provider, or the tenant can submit to the housing provider. So that's all that I had. I think we have a little time for questions if there are any.
Participants may be able to unmute, but chat in the box if you would like to as well. I have one. What about service animals in training? What are the rules regarding that?
So Stephen, do you want to take that?
Wow. You know, I always have a little bit of problem with understanding who's training the dog. If the people living in the apartment are training the dog, you know, yes, you can then. I think there's certainly the exemption for the dog and for the pet. That shouldn't be a problem. But I'm not always sure I understand what the in training means. Jessica, can you help me out with that at all?
So I think this is complicated because there's the ADA versus the Fair Housing laws. I don't know if the Fair Housing Act, like, I don't know that HUD guidance speaks to that specifically. I'm just not sure off the top of my head. I know in Connecticut, I was actually just looking at this law yesterday, there is a statute specifically related to service animals who are providing guide dog services and a couple other conditions, and service dogs in training are allowed in like public spaces and other people's homes. I think it would not make sense that they wouldn't be allowed in someone's own home if you can bring it to someone else's home. But I think, you know, if this is an issue for you, give us or Stephen a call just to double check. And it is confusing bringing an animal to a store, because some stores or businesses allow any type of animal, including pets. So this is a complex area with a lot of confusion, I think.
Been a lot of changes in this area as well lately. It used to be you couldn't bring animals in anywhere. Now you can bring them in almost anywhere, and all these differentiations of things are making it a little bit difficult to figure out. But most places don't even object to you bringing your pets in. So.
And do you mind going back through the slide, just showing your contact information again, both Jessica and Steve? I think it's at the beginning. But yeah, if anyone has any further questions, or especially if anyone needs the disability letter accommodation generator, needs a little bit of guidance. Obviously, Connecticut Fair Housing is the leader in that. And I'll go ahead and share the link for that disability letter generator to everybody. And then if you would like, please share in the chat if you'd like to sign up on our DRCT newsletter, our monthly newsletter, and to get more updates on this.
In our website, Connecticut Fair Housing, or ctfairhousing.org, we have a weekly update email that goes out with changes and sort of current events that are going on, especially with related to COVID and the Unite CT rental program. So you can find that information on our website and in our weekly update if you're kind of following the various rental assistance programs and moratoriums that keep changing.
Great. With that, if we have no other closing remarks, I'll go ahead and close this meeting early. Is that okay?
Sure.
All right. Well, thank you, everybody. I really appreciate everyone coming. Thank you so much for the presenters, both of you, to be able to come today. It's not easy to get attorneys to come and present. So I want to say that. So I just want to give a big shout out to thank you for making your time available for us.
Thanks for having us.
Yeah, and Rashida Ray as well. Thank you for your tech assistance and the interpreters. So thank you. And the cap.
Take care.
All right. Bye-bye.
Bye. Thank you.